with this part is two pieces. We have a wonderful panel of international policymakers. To my far right is Ventsislav Karadjov. Karadjov, excuse me, sorry. My Bulgarian pronunciation is needs a little bit of work. We are thrilled to have him. He is the head of the Data Protection Authority in Bulgaria and is the newly elected this past fall vice chairman of the European Union's Article 29 Working Party. And we have, to my immediate right, José Bermúdez, who is the head of the Data Protection Authority in Colombia, and has been very active in the Latin American data protection activities in other countries. And it's actually quite exciting because, as I learned at lunch today, this is the first time either of these regulators have spoken in the United States. And at least in José's case, he is here, this is a first for CLIP, he is here by decree of the President of Colombia. He needed a presidential decree to be able to participate in our conference today. So we're very excited about that. What we're going to do is we're going to start. Ventsislav has some remarks that he's prepared. There is also a copy of them if on the way out during the break. If you want a copy of them, we have it reproduced at the registration desk. And then José will tell us a bit about some of the events happening in Latin America and in Colombia, and then we'll launch into more of a dialogue and question and answer time. So with that, I will turn it over.
Thank you. Is that working? No?
Yes. Bring it towards you a little bit, and it'll be fine.
Okay. That works, okay. First, I would like to start presenting my small paper by introduction because I've been listening to this morning panelists, and I would say that my way of thinking about privacy and data protection are a little bit different. First, I consider that the value is the privacy right, the fundamental right of the individual. And as such, it has to be protected because the individuals are the vulnerable in the relationship with the government and with the companies. And so I would say that we, the data protection lawyers, we think where is the value and which is the value chain. So once we identify the value, we have to identify the strategies and the actions and to target the final results to protect this value. From that perspective, I would talk today about the new horizons I see for protecting this fundamental privacy right of the individuals. First, I would agree with this morning panelists that data is the heart of the public and social life, and information is the main asset of today's digital economy, which on one hand allows companies to operate globally, but on the other poses a big challenge to privacy. The effect that global economy and development of technologies have on the private life has launched efforts for an advanced privacy protection system, notably the fundamental right of personal data protection. These days, we face a crisis of trust. People are concerned and obsessed by the very fact that their personal data is already publicly exposed and obtained and utilized by the net, not only disclosed to state, local institutions or providers of services. From that perspective, I think that the policymakers around the globe have to act and in public dialogue in first place to resolve trust gap in data collection and flows that are transfers of data. Privacy has huge economic potential as it fosters confidence of all actors. The various privacy regulations and reforms aim to create and deliver better protection for citizens, legal certainty for companies, and common set of measures to ensure consistency of data processing and safeguards to individuals. Current rules on data protection need to be modernized in light of rapid technological development, of course, and globalization. This primary goal is achievable by efforts of all stakeholders, encouraging and contributing to the global data protection reform package. Companies and governments, that's my belief, shall reconsider their opinions about privacy, because they have not to consider privacy rights as an obstacle, but rather as a solution. And protection of privacy rights should not be considered compliance costs, but an asset. Two main objectives are on the new horizon for reform. And that's my understanding. This is the reinforcing the protection of privacy and strengthening the independent supervision as an instrument for improving compliance. These are the data protection authorities, of course, and mechanism to seek and ensure justice for the data subject. Because if the data subject does not feel protected into this relationship, it does not get justice from that supervising authority, we are losing the opportunities of building trust. The key privacy actors, according to myself, are, of course, the state, the data subjects, I mean the individual, and the controllers of personal data. So that's why I think that solving privacy is a process that needs active involvement of all public and social levels. Privacy must, in first place, be protected by the state. What we need is comprehensive, long-lasting state strategies on how to better manage privacy issues in terms of supervision and how to reconcile the various counterbalancing rights that are, for example, the right of privacy versus the freedom of expression, or the right to public information. Also, privacy versus public security. My understanding is that the responsibility of the state is to develop the common vision, to encourage the development of technologies that respect human dignity and freedoms and keep the digital infrastructure under control. To make personal data not only major political issue, but protected and enforceable fundamental right. It is also the responsibility of the state logistically to encourage wide public participation and decision-making process to hear all actors concerned. Privacy is a collective responsibility. It's a responsibility of every one of us, part of the society, and as such, right to privacy should be a subject to wide public debate and also public monitoring. To this end, we have to build networks to streamline the common privacy vision through involvement of various counterparts of both sides of the Atlantic in order to assert data protection principles. And last but not least, I think that privacy is a personal responsibility that includes privacy knowledge and awareness about various privacy risks and data protection rights. It is a long educational process that should start at the earliest ages, which means to grow up with the idea that data has value. The aim of our common efforts is to develop a high level of protection by establishing a set of rules and best practices to comply with where such rules must not be considered as an obstacle by citizens and data controllers. Here in my presentation, I have concentrated also on the common tools for global privacy solutions, which you can have it and go in a big detail. I'm ready to answer all your questions. I have enumerated various regulations, including the Universal Declaration of Human Rights, the OECD guidelines, Council of Europe Convention 108 for the protection of individuals with regard to automatic processing of personal data, which is currently under consideration also by the Council of Europe, and have stopped on the EU-US relationships, more specifically on Safe Harbor scheme, which modernization of Safe Harbor for Europeans is crucial for restoring trust of companies complying with the principles of Safe Harbor and citizens whose personal data are transferred for commercial purposes under this scheme. The European Commission, on its behalf, has suggested 13 recommendations to improve the functioning of Safe Harbor, where the outlined areas of improvement are transparency, redress, enforcement, and regulated access by the US authority. The other important thing that I am ready today to discuss is the streamlining of opportunity for negotiation, considering the umbrella agreement between Europe and US, the revision of TFTP agreement, which is right now under discussion with Working Party 29. And at the end, my understanding is that when we're speaking about privacy, we have also to have in mind that big data and compliance with the data, with privacy principles is of utmost importance. The principles of data minimization, purpose limitation, necessity, and proportionality should be followed. Doesn't matter of the difficulty of processing, and these principles should be equal for all companies, even though the price for securing personal data and privacy of individuals may be higher. From my perspective, the most important is the value, and I don't consider that that will bring to illegal, violation of a competency between companies, because once you have certain rules established and observed by government, they are for everybody, and the price will be paid from the individuals and from the companies and from the state. But that is something that we have to take on our own shoulders if we want to secure enough high level of privacy and data protection.
Thank you. José, do you want to start?
Yes, thank you very much. I wanted to start by thanking Fordham and thanking Clip and Joel and Cameron and and the team for this invitation. It had to go to a presidential decree to be able to be here, so it was a hard struggle, hard bureaucratic struggle, but finally I was able to make the trip, and I'm very happy that I was able to make this trip and speak here today. So the title of the conference, which as you mentioned, is of course very ambitious. Solving privacy and how to solve privacy connections around the world, or how to solve privacy around the world, brings us to the fact of putting on the table here what's happening in Colombia in particular, and what's happening in Latin America in terms of data protection, how the situation has evolved, how we have been increasingly adopting regulations in the region, which to a great extent mirror or are inspired by European regulations, and that to say that just to put the Colombian example, we started with a fundamental right back in 1991, fundamental right which was only enforceable via special constitutional protection actions, which should be or must be filed and can still be filed through the judicial system, but we lacked the capacity to conduct actual investigations within an administrative authority, which was something that only happened in 2009 with the adoption of a financial credit history information bill, which gave us authority to conduct investigations back in 2009, and in 2012 with the adoption of the General Data Protection Statute, which is the statute that gave us in the Superintendents of Industry and Commerce the actual capacities as a formal administrative body to conduct investigations and impose fines and produce instructions and act as a formal DPA. That happened only in 2012, so it's a relatively new branch of an existing authority, which is the Superintendents of Industry and Commerce, but we've only been working as formal data protection authority since 2012. What happened was we have a statute which is, of course, based on the fact that data protection is a fundamental right in Colombia. That being said, it draws heavily from European legislation, but we've also made a big effort to try to understand the realities of data flows in the world, how data is moved, how data is transferred, how data is used by companies, and that process of thinking how data is actually moved took us to a process of consultation and finally drafting secondary regulations in Colombia in 2013, which incorporate some principles and some, I wouldn't like to say interpretations, but interpretations of the law which bring in certain flexibility that accommodates to the way data is moved around the world. Flexibility such as understanding that consent can be given in a multiple variety of forms. That's a concept that had already been peacefully adopted by the Article 29 Working Party in the papers of consent and the opinion of consent drafted back in 2011. They had already acknowledged the fact that consent could be provided by what we call conducts of the individual, which can be asserted to give an indication that there is a willingness to provide the data for a specific use. We incorporated a simplified notice, which simplified what we already had in our law, and I fully agree with what Joanne McNabb said in the panel this morning. Privacy policies are, in fact, documents which are important for regulators to address, to understand, and they will be the documents to which companies will be held accountable if they don't deliver and comply with the promises made in the privacy policies. But privacy policies are, of course, bad examples of communication to consumers. I fully agree with that statement, and that's something that has to be dealt with in order to effectively protect the consumer and in order to effectively guarantee the fundamental rights of citizens around the world. This is something that we hear this in every privacy forum all around the world, and there doesn't seem to be a specific solution yet, but it's something that we need to tackle, and we can't stick to the formal notice and consent notice system as it stands today. A third very important element that was introduced in the secondary regulation was the concept of recognizing accountability as one of the major principles of the regulation. Accountability was introduced in 2013, some 3 months or 4 months before the actual publication of the revision of the OECD guidelines, which actually incorporated and elaborated more on how to implement an accountability-based program within the organization. Of course, we drew from the discussions that were being held in the OECD. Colombia is in the process of joining joining the OECD, and that should probably be happening in the next couple of years. pending the revisions of the former WISP and the Digital Rights Committee. But we drew from that discussion and incorporated those elements of accountability within the secondary regulation, and we're soon going to publish, in a couple of weeks, we're going to publish the Colombian accountability guidelines based a lot on the Canadian and Hong Kong guidelines, which were issued a couple of years ago or some years ago. So that's going to be something which is going to be interesting for the next years. We're trying to put a lot of emphasis on accountability and an accountability-based model as a contrast to the normal and regular compliance approach which has been taken by companies. There is a mandate to produce secondary regulations on codes of conduct or binding corporate rules, not in the same sense as European BCRs, but just producing regulations on codes of conduct. That's something that has not been done yet. To be totally honest, we're still in the process of thinking what the best solution to approaching codes of conduct is. Should we be thinking of an APEC inspired accountability agent model? Should we be thinking of having companies demonstrate accountability directly to the regulators? Should it be done in a sporadic way, or should it be done as a formal program that companies may be able to present their guidelines? So that's something that we're sort of working around. I don't know if you want me to go straight into the enforcement and the network, or should we?
Let me just ask you a question on that. Your comment about the APEC-inspired accountability model, is that just Colombia, or are you referring to a variety of other countries in South America?
To my knowledge, it's only Colombia, even though Colombia is not part of, it's not a part of APEC. APEC has closed membership since 1997. There's an interest of the government to join APEC, but there's been a moratorium since 97, I believe, and it's not likely to be open yet. But still, as a model, I think it's something. It's a model worth considering, and that's something that we're trying to sort of balance out. If it's kind of the way that we want to follow, or we want to follow a different, more BCR-inspired compliance, or a third approach.
Is your the accountability approach that you said is now taking an emphasis in Colombia, is that also being explored by some of the other Latin American countries?
I'm not sure it's currently being. Probably Mexico has provisions which incorporate accountability notions within their secondary regulations, and they have provided for regulations on codes of conduct, and that's been sort of a interesting, flexible, modern approach to how they view enforcement in the region. I'm not sure that it's a model that other countries are currently looking at, but I think the Ibero-American network is bringing some interesting transformations to the table and some interesting thoughts on what the role of the network should be, and how the network should start thinking on bringing different subjects to the table and bringing discussions to the table which were normally not under consideration. So I think it's a dialogue that needs to be put forward within that context.
That's just all.
Just see if I am able to intervene about the accountability. You may already know that in Europe it's in a process of development of new legislation. Right now there is a regulation 46 of 1990, and based on that regulation and Convention 108, the European data protection legislation is actually ruled. but in the morning it was well said that it is not harmonized in all of the 28 member countries. This will be done through the new regulation because even though it's a secondary legislation, the regulation is have an immediate impact into the local legislation of the 28 countries, and it should not be adopted as previously the directive allows that. So this new regulation on data protection requires the implementation of accountability principle for the controllers and the processors of data, and the establishment of the so-called data protection officer for companies which are dealing with significant amount of data, which data protection officers should be certified, and now it's going on the debate who is going to certify this data protection officer. That means there's going to be training, courses, and providing them a kind of a final certificate that they well understand and can implement the new regulation. The accountability, according to what is going on now as a debate, goes on 3 levels, as far as my knowledge is. First is the accountability inside of the controller and processor. That means that he has enough capable and educated people, documents, procedures, and etc. that can verify that he is processing the data lawfully and in compliance with the adopted in EU regulation rules. And second, he is in a way accountable to the individuals, the data subjects that are providing him the data, in a way that he informs them whether the data is correct. They have to exercise their right for rectification, for erasure if the data is not anymore of any use, etc. And the third accountability level is to the supervising authorities, as the data protection authority I am chairing. Because right now the procedure is with a notification or a kind of a registration. In my country, it is a kind of a mixed procedure. They notify the data protection authority, and we provide kind of additional. Actually, after they notify us, we register them. But what happens is that the procedure is mixed because they can start processing the data lawfully, and we cannot refuse them because the law says that. And then we supervise them. If this sensitive data, they cannot start processing it before registration and supervision control. But if the data is not sensitive, they can do it, and there is a follow-up supervision. So this follow-up supervision will be part of the accountability principle with the new regulation.
Could I ask, sorry to cut in for just 1 second, do you think the regulation has a prospect of actually being enacted in 2016?
Well, I cannot say right now because the European Parliament already backed up this document prepared from the European Commission in 2013, in the summer, I think so. Now, under the Latvian presidency of the European Union, they are doing their best to try to convince member countries in some of the debating texts of the regulation, because Germany and other countries are very active, and they are introducing new rules, for example, for data of children, processed data of children. And they are they are putting on a debate opportunities for strengthening the rules on protection of data of children. Especially becomes very arguable the situation when children are browsing in internet, and then how they are gonna get consent from service providers, or if they use, for example, different services on playing games on internet. So they are requested to provide some personal data there, and to what extent their choice is informed, as we were discussing here in this morning. Do we have an agreement that the choice has to be informed in order to have a consent? And then the other discussion is to what extent the consent has to be explicit, for example, in this case, or it should be ambiguous. And so it becomes another set of discussions on this issue. And within the new provisions, yes.
But there's certainly some, in January, the Dutch presidency takes over, and I would think there'll be a very strong push at that point to try to finally close it out.
Yes, but you have to know that some of the member countries still does not agree on the text, and until a consent is not reached, it will be difficult for the European Council to approve this document, because you know, the European Parliament, these are the MPs that are designated by the countries, and the Commission is the executive body, but the Council is situated by the heads of state or government, and it's a political decision that has to be reached there, which won't be very, very fast. And once they get to that agreement, it will go into the trilogue. And means all these three institutions, the Parliament, the European Commission, and the Council, they have to meet together, and they have to have a final say on each of the text of the new regulation. This process will be quite long and not very easy to get to a solution, but I think probably in a year and a half period, there is a good opportunity that this regulation is adopted. Another problem for the adoption of the regulation now becomes the request of some of the member countries, this regulation to be in a package, adopted in a package with the directive for police and judiciary processing of personal data for investigation purposes, which becomes a serious issue, because the regulation is at a very early stage of discussion, I would say, compared to the directive. The regulation is in an advanced stage compared to the directive.
Jose, from Latin America, how concerned are you about the specific directions that the European data regulation may take?
Well, what I'd say is there's a dialogue going on in Latin American countries, and some of the Latin American countries, including Colombia, the first impulse for the enactment, and that's stated as clear as that in the Congress minutes, which actually then gave birth to the regulation. The impulse came from BPO companies operating in Colombia, operating in Latin America, of the fact that they were enacting the regulation in order to go after an adequacy decision by Europe, and that's stated in the minutes of Congress. So there was a real concern or a real interest in gaining adequacy and working towards adequacy. Some Latin American countries have, or 2 Latin American countries have gained adequacy decisions, Argentina and Uruguay. Some Latin American countries, including Colombia, have formally applied for a review towards a decision on adequacy. My impression, that's something that's conducted by the Ministry of Commerce and the State Department, or the equivalent to the State Department. Interest has sort of declined a bit after the initial impulse. And there has been a conversation within the Latin American community and within the Latin American network to start acting as a community in a more and as a network in a more connected way. Not only working towards enforcement, which is something that we need to improve upon within the network, but also working as a coordinated regional model that, for example, could eventually, and this is not something that has been formally discussed, this is just an idea that's been floated around, for example, start a mutual recognition between Latin American countries that would facilitate transfers. And that was the discussion that we had with some global companies last week in our meeting in Lima. There was, of course, a big concern of companies that have global operations, saying how can we actually know what our base program should be if we don't have an actual sense of the differences that can occur between a Colombian enforcement action and an Argentinian enforcement action, or an enforcement action which originates in Peru. And there's going to be at least a discussion on how, as a network, we can start to do something similar to what Article 29 has been doing in Europe, having unified positions to the extent that that position does not conflict with national authorities. Of course, there's no mandate as in the European directive to have a consultation body within the Latin American context, but I believe that it's a workable situation if we can agree upon it with other Latin American members.
It'd be a really interesting development if you would essentially be creating 4 sort of regional, we'll call it regional, the ones not regional blocks. You'd have the APEC bloc, North America, particularly the United States, sort of standing out in one position. If the Latin American countries are now organizing as a regional association in some form, and then the European groups, very interesting, different kind of landscape a couple years from now, if that comes to pass. Let me see if we got some questions from those in the room. I figured we probably would. Why don't we start in the back? If you could identify yourself, please.
Sure. My name's Steve Ehrlich. I work for a company based in New York called Spitzberg Partners. We advise tech firms on political and regulatory issues. And I wanted to thank you both for your comments. And my question's for you, Mr. Karadjov. There's a lot going on with as far as Europe and data protection regulations, from the EU antitrust suit to reforming Safe Harbor to the GDPR to the digital single market strategy that was announced last week. And I was just curious, I know this is not all your responsibility or purview, but I was just curious, how do you think this is playing out the rest of the world? Because there's so many issues ongoing. They seem to be very, very tied together. And when it comes down to it, it seems like the GDPR, since the text was first introduced in 2012 by Commissioner Reding, to me it seems that if that is not able to be passed by the end of the year, which has been promised, it would be a very big loss of face for the EU, considering the stakes and how it seems to be a precursor for everything else. So I was just curious what your thoughts are on that.
Well, me as an European, I would support any action of a faster adoption of the regulation, because the General Data Protection Regulation will harmonize the legislation and implementation of that legislation in all 28 countries of the European Union. But I would say the slowly the better, because we have a lot of differences right now as a member countries on different texts. And it's better that we get consensus on this text, because the new regulation actually what it's doing right now is establishing an independent type of regulatory body, which is European Data Protection Board. This board will have abiding decisions on the way how the regulation is going to be implemented. And on some cases, which he would be probably targeted through the data protection authorities or controllers and requested to decide on them. And for that reason, I would say it would be better that all the 28 member countries have equal understanding of the different texts of the new regulation, because that will save work to the new Data Protection Board and will make the easier the kickoff of the implementation of the directive. It will require changes in the way how some of the data protection authorities are thinking and understanding the data protection law, because some of them are not equipped right now with enough investigative powers, with enough advisory powers, and that will change significantly their daily life, because the Data Protection Authority I'm chairing is doing that on a daily basis, and I know other data protection authorities which are only doing advisory and kind of soft supervising activities on the controllers. And the new regulation is going to empower them with powers which I'm not sure that they will be able immediately to exercise.
I think,
Thank you. I don't know if, excuse me, if you're familiar with some research that was done by a couple of academics in California called Privacy on the Books and on the Ground. It's a study of some EU data protection regimes and American much less comprehensive privacy regulation, and then also of the culture in companies, major companies in under both systems. And their significant finding was that whereas the laws are more elaborate in the EU than in the US, that the company culture is more meaningfully compliant with what laws there are in the US than in many or some European jurisdictions, that the compliance is a sort of paper compliance of registering and filling out forms, but not an active, significant policy and implementation compliance. What do you think of that, or what do you think of that in your countries?
First, I think that the legislation is significantly differs. European legislation is very elaborate, and it gives a lot of powers to the data protection authorities. For example, the data protection authority I chair, we not only get complaints of individuals, we investigate them, and we have a public hearing. And so it's like quasi court procedure, and we have a decision on this case, which is administrative act, and this act can be redressed to court later on. But sanctions under the European legislation are very dissuasive, very, very high. which actually disappoints, if I can say so, the data controllers of repeating the illegal proceeding that they've been sanctioned to. And under the European legislation, the responsibility for the controller and the processor is the same. The processor, the controller is, and the processor are taking a collective responsibility for the violation of the data protection law. The idea is that, and it is now also under debate in the new regulation, is to stay the same regime of sanctioning the controller and the processor, because the controller is the one who is responsible of signing the contracts with the processor, of whether cloud computing, etc. And the data subject, that is the individual, the citizen, does not have a way to know whom they have signed such kind of contracts, and it's not actually doesn't matter for him, because he is providing the consent or is providing his data required by law to the controller. So the controller should follow very carefully with the processor that he is complying with the legislation, and he fails to do so, then he has to take this responsibility on himself that he's not doing correctly his duties under the legislation for data protection. So this is the difference, In the morning, I was listening to panelists that they were talking, we are the companies, but the data is processed somewhere else, and etc. European legislation does not make a difference who is the processor and who is the controller. Might be a different the sanction once we review the case and we identify that the processor has done infringement that is less sanctionable, of course, then we will individualize the sanction based on the violation. But they both are going to be sanctioned.
If I could just add that I wouldn't want to comment on the differences between European companies and U.S. companies on how they address the building of a privacy program within their organizations. But what I would say, in these type of forums, you tend to hear sometimes that the protection to citizens in the U.S. is under par to protection to citizens in European legislations, and I would just have to say that I think that's absolutely not true. I have the highest regard and the highest respect for the FTC in the U.S. I think they've done a tremendous job in addressing consumer and citizens' concerns within companies. I think that model has worked in a very good way, sending a message across to industry as to what the expectations of the regulator are, what the expectations of the FTC as a commissioner are, and I think that is a model which when seen in practice, makes that debate absolutely futile, because there's actually a very good enforcement in the U.S. So sort of leading on that direction, we have tried to bring this new concept of, or new concept new concept to Latin America, and of establishing an accountability culture. I do believe that even though we're going to have to establish a formal registration within the country, and that's a mandate of law, which I'm at least a bit skeptical to see how it's going to work. But I believe we have to shift the compliance from formalities to actually verifying that companies are doing a good job in holding up to what they promised within their program. So I think that's at least I see it as a good way forward.
We had a question over here before.
Mr. Durana, would you comment on the Colombian feeling with regard to EU efforts to establish a right to be forgotten?
Yes, sure. You had to ask that question, right? There's been this is another subject which I think has started. It started some years ago with a different involved actors in absolute opposites, and we're starting to see that there has been a productive dialogue, and you can see, or at least I perceive a change in Google's speech a year ago or 2 years ago, and Google's speech today, or last week when we had the same debate with the Spanish commissioner in the Lima meeting of the Ibero-American network. There was a decision in January by the Mexican authority, the former IFAI, which is now called INAI, on the right to be forgotten. We have had in Colombia some approaches by individual complaints asking for a right to be forgotten. We denied a first request a couple of months ago because it was a request clearly linked to a newspaper article, which we absolutely disregarded as non-applicable in Colombian law. We have a strong belief that when there is a real tension between freedom of expression and freedom of the press versus the right to be versus a possibility of being erased in the internet, this has to cede towards the protection of freedom of the press and freedom of expression. So that's something that we disregard in that complaint. But I do believe that there are some situations in which the right to be forgotten, of course, has a name which is not exactly or doesn't exactly reflect the actual decision taken by the actual decision decision taken by the European Court of Justice in that Costeja versus Spanish agency decision. Rights of the individuals should be upheld online or offline, and that's something which we have a mandate to do as data protection authorities. I believe that there should be some kind of filter of the data protection authority, because somehow having that decisions only in the hands of a search engine could yield trouble with having excessive deletions on the web, and that could pose a problem to freedom of expression. So I think there's a need to have a more active involvement of DPAs in that process of applying a so-called right to be forgotten in the internet. We have a specific case right now where we issued a preliminary order, sort of a what you would call an injunction in the U.S. On a company which was publishing. We talked about this over dinner last night with some of you. There's a company that was scraping off information from the judicial system, which was publicly available information, public information concerning legal procedures, judicial procedures of some citizens. And they presented that information on a website which was presented in a way that was misleading to the public. So it was public information, but it was presented in a way which is misleading to the public. That's a website operating or which has information from Mexico, Colombia, Argentina, Chile, Peru, Ecuador, and a lot of other countries. And their servers are stationed in Panama, which is no data protection authority, and we've had big trouble trying to see how we bring that page down, because it's a clearly deceptive practice put on forward by them. Should a right to be forgotten be applied in that specific situation with search engines? Probably yes. We haven't arrived to that conclusion quite yet, but that would be a decision which would which would be taken after having DPAs involved in the process of assessing if we are facing a deceptive practice within a website. We've been sort of cautious in how we tackle this problem. We don't want to, we want to be cautious on what our edge is going to be in that. I don't know if I sort of answered the question.
I'm always fascinated by a statistic, which is the number of requests to have personal information removed is about 1% of the number of, this is for Google, is about 1% or less of the number of requests to have copyrighted material removed. So on the expression side for copyright, the requests and the takedowns just totally dwarf any of the requests to have personal information removed. Did you want to add one last comment, and then we'll have to close this session?
Yeah, okay. My understanding about the right to be forgotten, it's a presidential right, I would say so, of the court, of the European Court of Justice. And it comes because the other privacy rights, like the right to get information from the controller or the processor, the right to correct that information or to request erasure, they cannot be implemented in the case of Google. Because Google claims, and other as Google, that they're search engines. Means they're neither processors nor controllers. And so the data subject cannot address his requests to, if they are not controllers or processors, they cannot be addressed with a request for implementation, enforcement of the other rights that the data subjects has under the European legislation. So I think that this decision of the court is a kind of a supplementing the legislation with a decision which is a kind of a theoretically not very correct, I would say. But in practice, there is no other way to enforce privacy, because these agents, they are they're doing a linking work with various databases. In practice, you would never get this information from this database if there is no link to it. And that's why it was developed, this right to be forgotten. I mean, people has the right, these links which provide incorrect information for them to be removed, and so others to forget about information which is not correct or outdated about them.
Wonderful. Well, please join me in thanking our policymakers for a fascinating session. We'll take